Hi, I'm Jack Price. I teach civil procedure at University of Richmond School of Law, and I am here to help you tackle an Erie question. Okay, first thing you have to do to tackle an Erie question is just figure out if you even have an Erie question. An Erie question could be in a problem if you're in federal court and there is a question whether or not the federal court should apply state or federal law. If that's the situation, you've got Erie on your hands. Okay? If you're in federal court and there is a question whether or not to apply state or federal law, you've got Erie on your hands. You've recognized the problem. What do you do about it? So Erie is a big, complicated doctrine, but we can simplify it around one central principle. When you see this Erie question, you become a legal scientist. You know, like a scientist goes out in the woods and studies animals, classifies them, and says, oh, that's a gorilla or that's an orangutan, right? Like Jane Goodall would do. You're a legal scientist. You look at the federal law that's involved in the lawsuit, that federal law, and you classify it the same way Jane Goodall or any other scientist would do. You classify it. Okay, so how do you classify it? In one category or in one side of your analysis, you say, is this thing that I see as a legal scientist with your, monocle on, you say, is this a constitutional provision, this law, that federal law? Is it a statutory provision, or is it a federal rule of civil procedure? Okay? If it is one of those, you sit it on this side, and your analysis, therefore, is straightforward. The court applies the law. That's it. That's Erie. You just applied Erie. That's the entire analysis. If you're in federal court and there's a question whether or not to apply state or federal law, you put on your scientific monocle, you go out and you study this beast of federal law, you figure out that it is a federal statute, a constitutional provision, or it is a federal civil procedure, then you simply apply that law. Why? Because the Supremacy Clause says to apply that law. The Supremacy Clause says to apply it. Federal judges are zombies to text. They stop thinking, they put out their arms like any zombie would, and they simply apply the law. Okay, straightforward. When you're out there with your monocle, though, what happens if you cannot, or rather do not, classify this federal law as something like the Constitution, the Federal Rules of Civil Procedure, or an explicit federal statute? Well, what else is there if it's not one of those? Well, there's a large category of things that are just sort of federal practice, policy. You could call it procedure, but it's not procedure that's reduced to a statutory form or a rule. It could have its existence in precedent. It could have its existence simply in habit. It's anything that courts do on a regular basis, federal courts do on a regular basis, that is not enshrined in the text of a statute, the text of the Constitution, or the text of a federal rule of civil procedure. So when you're out there looking at this law, do you say to yourself, is this law enshrined in some way, or does it owe its existence to the existence of one of these textual devices, or is it somewhere floating out in the mist, right? Is it something else? So if it is something else, what do? You do not turn into a zombie. If it is something else, you have to ask yourself a further question. You say to yourself, I will stick with this practice. Pretend you're the federal judge. The federal judge will stick with this policy, practice, ordinary habit, unless sticking with it causes forum shopping. So the federal judge says, all right, there's no federal statute, constitutional provision, or FRCP telling me what to do. So the question is whether or not I should continue with my ordinary practice or habit, or should give up on that habit and do what state law says to do. All right. And I guess what I'll do is question whether or not forum shopping will happen. That's what the federal judge will do, and that's what you should do to tackle an Erie problem. Let me offer two quick examples. Okay, two quick examples on this side of the analysis. That's this side. Remember, this side is you've got constitutional text, statutory text, or an FRCP. On this side, you've got policy, practice, habit, something informal not tied to text. Suppose a litigant says, hey, Your Honor, you need to put on a white wig before we start the trial. The judge is like, you're crazy. I'm not putting on a white wig. Well, listen, Your Honor, it's a diversity case. Here's what the judge does. The judge says, well, listen, my habit of what headwear I put on before a trial is not enshrined in Anything over here, no statute, no constitution or FRCP. So therefore, I will do what I will ordinarily do, unless doing so will cause forum shopping. And you know what? No one is going to shop for a court based on whether the judge is wearing a wig, right? When I say forum shopping, I mean someone is seeking some advantage that's material or beneficial. Compare that to a different situation in which state law, in a particular instance, provides an automatic assessment of damages. Say, anyone who wins this type of lawsuit gets $500,000. Now, there's no federal statute that says you automatically get a certain amount, so we're not over here. So the judge is saying, well, listen, generally the way we do damages is we have just general principles. We figure out how much you were harmed, and then we say, well, that's worth about this. That's how we ordinarily do it. And so what would happen if the federal judge decides to just stick with the ordinary practice? Well, people will start shopping, right? People who want their guaranteed $500,000 are going to stick in state court. People who want the chance to avoid $500 or maybe claim more than $500 will try to go to federal court. Okay, final point on how to tackle. I've laid out these two possibilities here, whether there's a clear textual basis for doing something, or whether or not it's based in policy or practice. The one final part about Erie in tackling these questions is figuring out whether you're in this one or this one. A lot of times you're somewhere in the middle, and that's a question of interpretation, right? When the court interprets a text, they say, well, this is what it means, and everyone knows, well, it doesn't exactly say that. So you may have a problem, I say a problem, a challenge, an analytical sort of responsibility to determine whether or not the law that is sought, the federal law that is sought to be applied, is explicitly grounded in text or has sort of wandered into the world of doctrine that looks more common lawish. Okay, if you remember all of that together, you will do a great job tackling Erie. So good luck to you and take care.